When they sue the bank, they don't necessarily know who the bank's going to retain. And maybe they're taking a shot figuring the bank attorneys will not know the federal rules because they're so accustomed to practicing in state court.
The Weekly Friedman, your source for the most essential information in the default industry. With your host, Adam Friedman.
On this episode of the Weekly Friedman, we're diving into the quiet title action, Article 13 LLC versus LaSalle Bank. In this potentially industry-shaping case, the U.S. Court of Appeals for the Second Circuit once again requested that the New York Court of Appeals weigh in on the Foreclosure Abuse Prevention Act retroactively, but in an even broader manner than before. Joining me to break it all down is Friedman Vartolo, appellate attorney, Steve Vargas, who's been following this case closely and has some great insight into what it could mean for lenders, servicers, and property owners. All right, Steve, thanks for coming back.
Oh, of course.
Always good to have you here. So what's going on with the case? Can you break it down for us in its most simple form so we can get an idea of what's going on?
Sure. I'm going to preface it by saying we've been tracking federal court cases in addition to the state court cases. And you'll notice this is now the second time we're talking about a federal court case that involves FAPA. And that's something that maybe would be unexpected because FAPA is a state law. But based on the diversity jurisdiction statute, mortgagees and mortgagors can bring lawsuits and defend lawsuits in federal court regarding mortgages that could be impacted by FAPA.
You're saying, we know this is a state law, right?
Yeah.
Why is it coming to the federal court?
So the federal court has a statute, 28 U.S.C. 1332A, which is a diversity jurisdiction statute. It allows parties that could bring state court claims, they could bring them in federal court if they can satisfy two statutory requirements. One would be the amount in controversy exceeds the sum of $75,000. The second would be that the plaintiff and defendants have to be citizens from different states. So as far as the first factor, in the context of a mortgage in New York, in most circumstances, the mortgage principal balance, which is what the threshold is, would exceed $75,000. So that typically is met. As far as diversity of citizenship, it depends on corporate entities, natural persons. There's an analysis that goes into place for corporations. Natural persons is based on domicile, which is pretty intuitive. For corporations, in the case we're talking about an LLC, it's going to be the state of incorporation, principal place of business. Sometimes they even look at the citizenship of each of the members of an LLC. So there's a technical nuance to that. We don't have to get into it today, but as long as they can plead that diversity exists, they can at least take the shot and sue in federal court. And here, the LLC claimed it was citizen of state A, the bank, a citizen of state B, the mortgage principal balance exceeds $75,000, the property value exceeds $75,000. Based on that, you actually had a subordinate mortgagee suing a senior mortgagee, something we haven't really talked about. A unique situation where the subordinate mortgagee is looking to discharge the senior mortgagee's mortgage to basically get the property free and clear.
The fact that this was brought in federal court, was that a strategy move?
I think it was. I think they're looking for a quicker decision. I don't necessarily think tactically federal court is going to issue a favorable decision while a state court would issue an unfavorable decision. But I think the plaintiff wanted to move the case along and take a shot in federal court by bringing this lawsuit in federal court as opposed to state court.
Okay, so there's not something where it's a state court statute and there's no thought here of, hey, we'll do better if we bring this case that's relying upon this state court statute in federal court. It's really just, we think the federal court will move quicker.
Yeah, that's oftentimes maybe the most common reason why a state court claimant would just bring a claim in federal court to try the shot there. There's something called forum shopping where you pick which court you think is more favorable. In a situation we're talking about, in theory, the federal court is applying state law to a state court claim. So in that sense, the law should be applied evenly. I think it's the speed. I think they're saying we can move this case along more quickly in federal court than state court. I think in this instance, knowing the plaintiff's attorneys, they're very seasoned litigators in federal court. So they may have figured, we know the federal rules, maybe our adversary won't. So when they sue the bank, they don't necessarily know who the bank's going to retain. And maybe they're taking a shot figuring the bank attorneys will not know the federal rules because they're so accustomed to practicing in state court. That's typically what you do, a tactical advantage, if anything.
So what's plaintiff's claim here?
So plaintiff's claiming that the statute of limitations to enforce the defendant's mortgage expired. The basis for this is there's a prior foreclosure action commenced by the mortgagee of record for the senior mortgage in 2007. That action was discontinued outside the statute of limitations and no subsequent foreclosure was brought. So when this case was brought by Article 13 LLC, which is the holder of a subordinate lien, there was no pending foreclosure. There was an acceleration that occurred more than 6 years prior to this action. The 6 years from that acceleration point, elapsed. So they're saying based on that, we can meet our prima facie case. With a 6-year SOL, we have an acceleration in 2007. We're bringing the case more than a decade later. Therefore, we've established the statute of limitations expired. Let the mortgagee explain otherwise. Let the senior mortgagee explain why it didn't expire.
And what did the federal court do?
The explanation, the defense to the case was that the alleged acceleration from 2007 was invalid because the entity that alleged to have authority to accelerate lacked standing to accelerate. There was no adjudication in the 2007 foreclosure whether or not the plaintiff in that case, the mortgagee, had standing. So it became a factual issue that got litigated in this case through affidavits and documentary evidence. So as far as what the court did, pre-FAPA, and that's again, we're talking about FAPA flipping the script on arguments. A case was brought pre-FAPA. Summary judgment motion briefing occurred initially pre-FAPA. FAPA then becomes law December 30th, 2022. The parties then have to rebrief the case based on the FAPA amendments. The federal trial court said FAPA applies retroactively, and based on the junior mortgagee plaintiff's argument, the mortgagee defendant was stopped. I'll get into that momentarily, what exactly is going on statutorily, was stopped from arguing that its predecessor lacked standing. So what the senior mortgagee was saying was that plaintiff commenced the case. However, even though the plaintiff filed the lawsuit through a law firm, that plaintiff actually didn't hold the note. So it wasn't authorized to file the lawsuit that it filed through counsel in the state court in 2007. FAPA created an amendment, CPLR 213-4, subsection B, which stopped a mortgagee from claiming that its predecessor or itself lacked standing to bring a prior foreclosure action. What it required in order to assert an argument like that was that the defendant in the foreclosure had to allege a lack of standing defense. The defendant in the foreclosure had to prevail on that defense. Basically, the judge had to dismiss the case based on a defendant's motion to dismiss for lack of standing. In that case, there's an adjudication about the lack of standing that a bank can rely on and say, well, the defendant won the last case by arguing a lack standing. So therefore, there's the evidence that I need to show I lack standing. In the absence of that, FAPA said you can't claim, in essence, you yourself or your predecessor lacked standing. To avail yourself, essentially filing a baseless lawsuit for foreclosure in the name of the wrong bank. So it's a technical argument that was being made.
So you're saying what FAPA said for the mortgage holder.
For the mortgagee, yeah.
The only way for the mortgagee to use an argument that an action was commenced on your mortgage by the incorrect party is if the defendant filed a motion in that case in which you're alleging the incorrect plaintiff was there starting the action and they won.
Exactly. There's 3 prongs to the analysis. It's defendant timely raises a lack of standing defense. Defendant ultimately makes a motion for summary judgment typically, or a preemptive motion to dismiss, alleging lack of standing, and the judge actually dismisses it for lack of standing. And in the dismissal says the case is dismissed for lack of standing. And in that instance, the bank could say there was never a valid acceleration. The statute of limitations couldn't have run based on the filing of that other action. So it gives us more time to bring the new lawsuit. In the absence of those 3 elements, the bank can't say, whoops, we made a mistake. We commenced the foreclosure in the name of the wrong bank. And now we're going to exploit essentially a mistake or a factual misstatement in a pleading to try to protect against the statute of limitations expiration down the road.
So let's say I'm a very creative borrower and I make up a demand letter and I send it from my bank to myself. And then I start a foreclosure action. And so it's Bank A, right? The bank is actually the Vargas bank. That's who holds the mortgage. But I send a demand letter from Bank A. I then file a complaint under Bank A, alleging that the Vargas bank has assigned the Vargas mortgage into me. I start my case, I go forward. Eventually it's thrown out because I'm just a random person claiming to be Bank A. I'm not the Vargas bank. There's no assignment of mortgage, there's nothing. And for whatever reason, the court throws it out. The defendant, who's me, because I'm also the property owner, right? I don't file a defense to the action, but the case is eventually thrown out for whatever reason. Certainly not in that situation. The borrower could eventually allege there was an acceleration, right?
It's a fraudulent action commenced by the borrower. So in that instance, by sending a false letter purporting to be a different entity, ultimately it would get litigated. The borrower filing false documents with the court is actually a felony, depending on what exactly is alleged. Ultimately, once that case gets litigated, the actual correct bank that holds the loan would prevail and prove we hold the loan. And whoever's filing these documents, whether they trace it back to the borrower or not, this is not a valid lawsuit.
I understand that my example is ridiculous. I knew it as I was saying it. But the reason why I'm bringing it up is the wrong bank is the wrong bank. So if someone else had commenced an action, how does that work logically? I understand that we're presuming, or the legislature is presuming, that it was a technicality. But can it also not be a technicality? Like, shouldn't there be a carve out for when the wrong bank actually commences an action or actually accelerates?
So I think in a situation like that, it probably would give rise to something along the lines of either a malpractice claim against the law firm that filed an action in behalf of the wrong entity, a facial defect in the case, maybe some sort of claim as against the predecessor entity. So let's say Bank A commences the lawsuit in its name when Bank B was actually the owner of the loan. Whatever the reasoning was, a mistake, typically it would be an error. Bank B may have recourse against Bank A to say, we own this loan. Why are you suing for foreclosure in your name, particularly through an attorney, because a corporation has to be represented by counsel in a case. A lot of it to me would fall back on counsel that filed the lawsuit in the name of the wrong bank. So I think it's probably, as far as recourse, like how would the correct bank get its money? It would probably be through some sort of malpractice claim against the law firm that lacked diligence in filing a lawsuit on behalf of essentially a non-client.
I think we also understand that that's not normally what happens.
No, it's an outlier situation. Right? 15 years ago, it was different. But
it's just an interesting thing to say that we would have thrown your case out because you didn't, like, the wrong plaintiff commenced.
Correct.
But that's not enough to say it wasn't accelerated. The wrong entity can accelerate.
FAPA created a statute that holds the actual note holder, actual correct mortgagee that to whom the money is owed, holds them responsible for a potential mistake by a prior law firm or some sort of misrepresentation by a prior bank. And to your point, it's an outlier situation. It is exceedingly rare these days. It was more difficult maybe 15, 20 years ago, which is when this was happening. In this case, the initial foreclosure was 18 years ago. So some law firm brought a case 18 years ago that was defective. And the legislature is saying, we're not going to allow you to escape some form of liability through an error of that nature. It's a serious enough error, but we're not going to let you get around it, the error of your predecessor or that law firm. But in terms of FAPA is concerned, there's a really interesting development here. This was like another step in the right direction in seeing what's going to happen in the FAPA evolution.
Thanks for joining Stephen Vargas and I on the Weekly Friedman, your source for the most essential information in the default